is step 2, notice of fault, opportunity to cure. Step 3, notice of default. And actually, step 4, enforcement, which you're going to be setting up your enforcement from step 2, where you're putting them on notices. Here's where I'm going to go if you do not perform within the next 10 days. Okay, because your notice of fault, opportunity to cure is saying, hey, I gave you so much time, whether it was 10 days, whether it was 30 days, to perform. You haven't. Here's your last chance before you're in default, and I move towards enforcement. See, once you've gone to step 3, which is the notice of default, certification by your witness of their default, you now have certification of their agreement and the contract, so you can now move forward with your enforcement because you have their agreement to move forward on enforcement. Okay, so I'll actually read through this just to give you an idea of the nature of it. I like this one. Actually, Gordon put this together. I've made some modifications to it. Is Gordon in here? Okay. So I've made some modifications to it. This particular process, because it's for debt collectors, we didn't actually make this process to be done through a notary. Okay, now I am going to do this same process and develop samples that will be a process through a notary. However, because there are so many that have difficulty with getting notaries, which now we've got a couple, I know, in this area that are doing processes and no presentment. And for those of our listeners and viewers in Canada and the UK, they have difficulty getting presentment because all the notaries are attorneys or solicitors or whatever you want to call them. Okay, so this is titled Respondents' Private International Remedy Demand. Okay? In the upper left-hand corner is the information of who this is coming from. Now the title is Private International, meaning between jurisdictions, from one jurisdiction to another jurisdiction, remedy and demand. So the address and name in the upper left-hand corner is a private address or an address from what we in the previous classes have called jurisdiction A. So it says John Henry Doe, uppercase, lowercase, the number and the name and the street, no abbreviations. No BLVD, no ST, no, you could do P.O. Box, but I don't recommend it. Because remember, post office sits on the fence. They're kind of both sides, but you would still have to make it a non-domestic address. And the way we do that is I also have the full name of the city, no abbreviations, the full name of the state, no abbreviations. Did you know capital C, capital A is a federal jurisdiction? Yes. It is not a state or the Republic of California. It's a federal zone, okay? And I put the zip code on here, but I put it in brackets. Those of you who did the class on admiralty, remember what it means to put something in brackets. It's not there. Underneath that, I put non-domestic without the U.S. What's the significance of that? You're outside the jurisdiction of the democracy. Has anyone tried to do the mail thing yet? Non-domestic? Have you done it? 3 cents?
Yeah, it's going out. I'm waiting for replies to come back in. I have a question on that.
Already? Can we hold on? A very important question. Okay. Well, there are again. There's several people I know in the first series of classes we did who did the non-domestic mail. Now, I don't use the 3-cent stamp if I'm doing a commercial process because I send the mail registered. Why am I sending it registered? As opposed to certified. Remember, this is not going through a notary, and this is specifically why I made this process not through a notary. If we're going through a notary can work on both sides. They can work in the democracy and without, or with the United States or without the United States. So they can send the mail certified because they're acting as an agent. They've already taken it from one jurisdiction, they brought it into their jurisdiction, and they're doing the mailing. Whereas if this is coming from me at a non-domestic location, I am not going to use certified mail. Certified mail, benefit and privilege. Registered mail specifically is geared towards this type of transaction. It's interesting. What color is the registered mail sticker? Red. It's red. Okay? What does red signify? Private. Okay? It's specifically for one jurisdiction to another. I've sent registered mail, no problem, to Puerto Rico. I've sent registered mail. You could pretty much probably send registered mail anywhere. Okay? So, in the upper right-hand corner, registered mail number, identifying the registration of my claim. So I have registered mail number and the registered mail number underneath, in parentheses, United States Postal Service. Okay, respondents, private international remedy and demand. Underneath that, notice to agent is notice to principal, notice to principal is notice to agent, and in parentheses, applicable to all successors and assigns. I don't know how many of you, see, I've done commercial processes with debt collectors in the past, and a lot of times they like to play hot potato. They're like, oh, I don't want to deal with this guy. And they pass it off to someone else, and then they pass it off to someone else, and I keep doing my process, and they keep running for the hills. Eventually, it was funny, I did this with a franchise tax board debt, and it ended up back at the franchise tax board because the debt collectors didn't want to deal with me doing the demands. They didn't want the liability, so they passed it back. They're like, hey, you keep it. We don't want it. We're not going to collect on it.
Did it get paid?
What's that?
Did it get accepted and paid?
Did it get accepted and paid? No, not by the debt collectors. They just passed it off.
Did they unconditionally accept your,
Did they unconditionally accept it?
the franchise board?
Well, they accepted it the first time.
Oh.
Right? When they didn't return my payment initially, they accepted it. So, it's all contract. Can you enforce your contract? Okay, respondent. Now, respondent in this particular letter, the respondent is who the debt collector is trying to collect from. Now, the debt collector sent the notice to an entity which is in jurisdiction B, signified by the name in all capital letters. Now, if the process were being done through that entity, would it be an international remedy and demand? No. That's why, again, registered mail, non-domestic address. But the respondent, all capital letters, John H. Doe. Alleged creditor, Debt Collectors, Inc., DBA, DCI Law Offices. Now, I think I made that name up, but there may actually be a company out there called Debt Collectors, Inc., and they may actually have a DBA called DCI Law Offices. I don't mean to offend. Alleged account. This is the account number that Debt Collectors, Inc., DCI Law Offices put on their alleged invoice or statement. Alleged amount, $125,000. Okay. The next subtitle, in all capital bold, offer of performance / conditions precedent. Number 1, this offer of performance is based on conditions precedent which must be fulfilled and is made with sincere intent of extinguishing any alleged debt, duty, obligation, liability, and the like, intended as obligating respondent, John H. Doe, all capital letters, hereinafter respondent in above reference respondent's private international remedy demand, hereinafter presentment. Number 2. Now, hereinafter, why do we do that? We're defining it. Now, so from this point on, when I use the word respondent with a capital R, it has a special definition. When I use the word presentment with a capital P, it has a special definition. Remember the Constitution? All the capital letters in there? It wasn't because they were writing fancy. But they didn't define any of those words because those words were to be defined later. They could define those words in the U.S. Code or in any other statute because now it's up to the interpretation of the Constitution. But because we use capital blessings, capital liberty, we can make those, the word blessings and the word liberty, the word state and the word citizen mean what we want it to mean. But we didn't define it. Notice, definitions are missing from the Constitution. Very rarely do I write a contract without definitions in it. Especially if I'm going to be if I don't use capital words in a contract unless I've defined those as in hereinafter. So I've given a clear distinction. This guy, John H. Doe, all capital letters, respondent. I've given a clear distinction that this private international remedy demand is presentment. Those words, terms are now defined. Number 2. Concerning this offer of performance, certain conditions precedent must be completely, unambiguously fulfilled by, quote-unquote, debt collector and or, quote-unquote, alleged creditor. In accord with Fair Debt Collection Processes Act and in brackets 15 U.S.C. 1692 et sequita, whereby verification is required of an alleged amount due. See, typically we don't use code. In this particular case, what we're doing in Title 15 is interesting because Title 15 is one of those sections of the U.S. Code that's actually positive law. So we may not be in the jurisdiction where Title 15 applies, but the debt collector and the respondent are. Whereby verification is required of an alleged amount due. Advisory note. The term verification is defined in Black's Law Dictionary, 6th edition, as confirmation of correctness, truth, or authenticity by affidavit, oath, or deposition. Affidavit of truth of matter states an object of verification is to assure good faith in averments or statements of party. The term verify is defined in Black's Law Dictionary, 6th edition, to confirm or substantiate by oath or affidavit, particularly used of making formal oath to accounts, petitions, pleadings, and other papers. The word verify, when used in statute, ordinarily imports a verity attested by the sanctity of an oath. It is frequently used interchangeably with sworn. To prove to be true, to confirm or establish the truth or truthfulness, to check or test the accuracy of or exactness of, to confirm or establish the authenticity of, to authenticate, to maintain, to affirm, to support, to second, back as friend. Cite omitted in parentheses. So, doesn't this sound a lot like what we're asking in a conditional acceptance? Aren't we asking for verification? Right? This offer of performance is made in good faith and is condition precedent on verification of an alleged debt. Conditions set forth are as follows. A, true, correct, complete, and not misleading copies of all assignments, negotiations, transfer of rights, novation, and the like, which unambiguously delineates that debt collector is the current owner, assignee, holder in due course, entitlement holder, which absolutely evidences alleged creditors' full and complete disclosure, including but not limited to any and all implied and or express written contracts and or any and all consent with any such agreement of a novation. B, please produce all relative commercial instruments, contracts, whether implied or express, which contain exchange of consideration and which contains verified, bona fide signature of respondent. Remember, this process is for a third-party debt collector. Do you have a contract with them?
They're third party interloper.
Do they have any verification that the debt is valid?
No.
Depends on whether the first person is private or not, though.
What do you mean? Who's the first person? The person who assigned the debt? Ask that question again?
You've got the debt collector.
Here, put it on the mic so that people don't get all upset.
Debt collectors collecting.
Turn it on.
Debt collectors collecting for someone, who's that party? Private or not private?
Well, if they're a debt collector, they're a corporation, right? They may
That's
be.
what I'm asking.
They may
Is
be
it a
collecting for
corporation or
an
not?
international entity, but
Right.
makes no difference.
But they're a corporation by definition?
A debt collector?
No. The party they're representing, the debt collector's representing.
More than likely.
Okay.
I mean, now, if it were a private party, could a private party, like, for instance, if I hired a debt collector to go collect, I could give them a verified statement of the debt. I could have multiple parties who have firsthand knowledge of the debt sign verifications of the debt. Now, they have a substantiated debt. They'd actually be under the guidelines of Title 15. Whereas 99.99999% of the time they're not. Please provide an absolute evidence of an equal exchange of a benefit for valuable consideration, including but not limited to an exchange or detriment, in parentheses, implied contract, unconscionable, adhesive, or otherwise. D, please produce any absolute evidence of any series of external acts giving the objective semblance of agreement. E, please produce any and all documentary evidence between respondent and debt collector and or alleged creditor that debt collector and or alleged creditor rely upon for making a presumptive claim. Can they produce that?
No.
Not unless you sign something with them. Please produce all relative commercial instruments and or notices, declarations, publications which clearly and unambiguously delineate that respondent was fully and completely apprised of all rights, duties, obligations, liabilities, costs, fees in advance or subsequent to the alleged incurrence of alleged debt, and where there has been full disclosure of all relevant terms and conditions. G, please complete and return debt collector disclosure statement. That's this 7-page document we're going to send along with it. Where was I? Please complete the return debt collector disclosure statement regarding offer of performance. H, please produce a certified copy of any and all verified judgments relative to this instant matter. Number 4, respondent expects a response regarding this offer of performance within a reasonable time of receipt of this offer, which is hereby set at 30 days, excluding the day of receipt. All responses shall be directed to the respondent at the address delineated on last page of this instrument. Respondent does not waive timeliness. However, if additional time is needed, debt collector and/or alleged creditor must make a request in writing before the expiration of the above 30-day time period prescribed in number 4, setting forth the debt collector's and/or alleged creditor's reasons for requesting such extension of time with good cause shown. All such requests for extension of time will be fully considered by respondent. Either the granting thereof for good cause shown or the denial thereof, however, such grant or denial is conditioned solely upon the decision of the respondent. What have we done there?
They basically only got 105 days.
Basically, if they send any response that we consider frivolous, we can deny it. It's up to our discretion whether or not we'll extend their time or not. Right, because we're actually asking for a specific response. We're asking them to answer these 54 questions, which are by Title 15 required. Wait till we get into these. Number 8. Wait, am I on number 8? Yeah, number 8. Respondent also expressly includes with this offer of performance a debt collector disclosure statement regarding offer of performance attached hereto and made a part hereof by this reference. To ensure debt collector and/or alleged creditor clearly and conspicuously make all disclosures in writing in accord with the Fair Debt Collections Act, in brackets 15 U.S.C. subsection 1692 et sequata, and in accord with the applicable portions of the Truth in Lending, Regulation Z, 12 CFR, that's probably supposed to be, it's CRF on here, so read carefully before you use any documents. Section 226 et sequata, debt collector disclosure statement and request for production of documents requested herein must be fully completed and received by respondent who will certify receipt or non-receipt within the prescribed 30-day time period of the debt collector and/or alleged creditor's receipt of this offer performance if debt collector and/or alleged creditor wish to have their claim considered by respondent. Now, if we were making this a process through a notary, we would change that paragraph ever so slightly. Instead of, where was it? Production of documents requested herein must be fully completed and received by respondent, would be fully completed and received by notary witness, notary public, whatever, because the notary public, in this statement, we would have stated that the notary public is going to certify their non-response. Number 9, debt collector and/or alleged creditor also tacitly consent and agree that both debt collector and/or alleged creditor have an absolute duty and obligation for preventing this alleged account from damnifying the respondent in any way, shape, or form, including but not limited to slander of credit upon debt collectors and/or alleged creditors' failure/refusal to timely respond will constitute their tacit acquiescence, thereby making tacit procuration that no bona fide, lawful, verifiable claim exists, past or present, thereby consenting and confessing judgment. Respondent reserves all rights and defenses, including but not limited to. Now, before I go into rights and defenses included but not limited to, slander of credit. What are we setting up here? Well, if they do, we're going to have a claim now because we've got their agreement not to slander the credit. So if they pursue a path of slandering credit, we now have their agreement to our enforcement against them in regards to that. Okay, so rights and defenses that we reserve, including but not limited to: initiating a counterclaim against debt collector and/or alleged creditor, filing a claim against the bond or insurance contract of any responsible party, including but not limited to debt collector and or alleged creditor, all principals, agents, assignees, employees of debt collector and or alleged creditor whose acts, actions, omissions result in any type or kind of tort damages, slander of credit, and the like against the respondent. Sound good? Okay. Privacy Act notice. The written communication, or this written communication, constitute respondents' due process notice for being heard, absent compliance with all requirements set forth herein. Debt collector and or alleged creditor are barred from using any defenses of immunity from prosecution for debt collectors and or alleged creditors' acts, actions, and omissions, including its/their principals, agents, assigns, employees, and the like. 11. By this notice, debt collector and or alleged creditor, including their principals, agents, assigns, employees, shall comply with the provisions of the Privacy Act of 1974 as lawfully amended at 12 U.S.C. Section 3401 and the Right to Financial Privacy Act of 1978 as lawfully amended at 5 U.S.C. Section 552A and the Third Party Summons Act Special Procedures 26 U.S.C. subsection 7609 for assisting the respondent in keeping inviolate certain constitutional protected privacy rights and guarantees and from preventing encroachment thereon. And all those code quotations, all in brackets. Now, throughout this entire document, every time we've referenced code, we've put it in brackets. Why would we do that? This is an international claim, right? Why would we want to joinder our international claim with United States Code? Isn't that a lower law form? Isn't this a superior or paramount law form? This is contract, the highest form of law. Statute comes under contract, and only, remember, we talked about in previous sessions, the only time law is in the courtroom is when? When you bring it there. So do I want to bring those laws and codes into my contract? No, I'm just making reference so that they know what they're violating over in their jurisdiction. Number 12, by this notice, debt collector and or alleged creditor, including but not limited to principals, agents, assignees, employees, shall comply with this demand. Debt collector and or alleged creditor shall provide respondent with a copy of any express written authorization from respondent whereby debt collector and or alleged creditor authorized for disclosing, divulging, sharing any type or kind of information with any third party in any manner, as well as by means of communication, any information, documentation, data, property, effects, and the like regarding respondent. Debt collector and or alleged creditors. Failure, refusal in providing said foregoing demanded authorization constitutes admission and stipulation that debt collector and or alleged creditor are in violation of, including but not limited to, Privacy Act. Number 13, debt collector and or alleged creditor possesses neither express written authorization nor consent from respondent for using, revealing, disclosing, divulging, sharing with any third party any secured information, documentation, data, property, effects, and the like of respondent. 14. Respondent's private international administrative remedy demand regarding offer of performance is binding upon every principal, agent, assignee, assignor, employer, employee, and the like regarding the subject matter set forth herein and herewith, and each and every principal and agent is A, barred from providing any credit reporting agency any derogatory credit information regarding the above referred debt. B, prohibited from contacting any other third party regarding the above referred alleged debt until debt collector and/or alleged creditor have established the existence of a bona fide, lawful, verifiable claim in substance and in fact, and until such alleged debt is verified as indicated herein and herewith. Advisory note. Fair Debt Collection Practices Act, 15 U.S.C., subsection 1692 et sequata, states in relevant part, a debt collector may not use any false, deceptive, or misleading representation or means in connection with the collection of any debt, which includes the false representation of the character or legal status of any debt, as well as the threat to take any legal action that cannot be legally taken, all of which constitute violations of law. 15 U.S.C. subsection 1692, paragraph E, subpart 8 states, communication or threatening to communicate to any person credit information which is known or which should be known to be false, including failure to communicate that a disputed debt is disputed, is a violation of subsection 1692E. 15, until the alleged debt is verified in accord with the Fair Debt Collection Practices Act and said verification is set to respondent, whose information is enumerated on the last page of this instrument, each and every contact received by respondent and any and all information which is not removed from the credit reporting agency constitutes harassment, slander of credit, defamation of character, creating a false public record by use of mails and wire communications with intent to obstruct lawfully communicated information and are subject to liability for damages as well as statutory damages, including any and all legal costs or fees incurred for each and every violation. Number 16, due process is guaranteed for respondent at debt collected and/or alleged creditor's Office of Risk Management and is codified in 18 U.S.C. subsections 4, 241, and 1963, and at 15 U.S.C. 1692 et cetera, and elsewhere. Respondent makes this good faith offer of performance with sincere intent to give debt collector and/or alleged creditor fair consideration and ample opportunity to provide respondent with absolute verification of debt in accordance with the terms and conditions set forth herein and herewith. Failure/refusal to comply with the terms and conditions set forth herein and herewith will result in debt collector and/or alleged creditor's waiver of any and all alleged claims and will be followed by a second witness, fault in dishonor, followed by a third witness, default in dishonor, executed this blank day of blank month, blank year. Respondent, John H. Doe, all capital letters. Authorized agent for respondent, signing, all rights and defenses expressly reserved. All responses to be directed to John H. Doe, all caps, and the address. Something to add, my friend? Okay. Now, the debt collector disclosure statement. My mic is dying. Starting to distort a bit. You want me to drop the volume, you mean? On the microphone or on your... How about now? Still? Well, then, okay. I mean, how about now? Can you still hear me? It might be the battery's going dead. Okay. I got batteries. Let me change my battery real quick. Uh-oh. What did I do with the document? There it is. Okay. This is, we'll be able to whip through this pretty quick. This is just 54 questions, which every debt collector is dying to answer. Debt collector disclosure statement regarding offer of performance. This statement and the answers contained herein may be used by respondent if necessary in any court of competent jurisdiction. Notice to agent is notice to principal is notice to agent, applicable to all successors and assigns. has the same information as on the first one, respondent, account, alleged amount, alleged creditor. Notice, this debt collector disclosure statement is not a substitute for nor the equivalent of the herein above requested verification of record, i.e. confirmation of correctness, truth, or authenticity by affidavit, oath, or deposition. Black's Law 6th edition regarding the alleged debt and be completed in accord and must be completed in accord with the Fair Credit Reporting Act at 15 U.S.C. subsection 1681 et sequa, and the Fair Debt Collection Practices Act at 15 U.S.C. subsection 1692 et sequa, and the applicable portions of Truth in Lending, Regulation Z, at 12 CFR Part 226 et sequa, and demands as cited above, offer of performance. Debt collector must make all required disclosures clearly, accurately, conspicuously in writing regarding the following. Number 1, name of debt collector. Number 2, address of debt collector. Number 3, name of alleged debtor. Number 4, address of alleged debtor. Number 5, alleged account number. Number 6, alleged debt owed. And number 7, date alleged debt became payable. Number 8, regarding this alleged account, what is the name and address of alleged original creditor if different from debt collector? Number 9, regarding this alleged account, if debt collector is different from alleged original creditor, does debt collector have bona fide affidavit of assignment for entering into alleged original contract between original creditor and alleged debtor? And we even put on there yes/no so that they could just circle it. Circle it. Yes or no? We don't want any confusion. We want them to know we just want a yes or a no here. We don't want to hear you walk in circles. Okay? Just answer the question. Did debt collector purchase this alleged account from the alleged original creditor? Yes or no? If applicable, date of purchase of this alleged account from original creditor and purchase amount. Why is that significant, Gordon?
By law, you can only collect what you paid for the debt. So when you consider that, how many debt collectors are out buying debt from banks? You think?
Pennies on the dollar.
Pennies?
10 cents on the
I can't imagine they're paying anything. It seems to me they're probably buying it for nothing more than a piece of the pie. It's possible, but I wouldn't, if I was a debt collector, I wouldn't want to buy anybody's bad credit card debt, would you?
That's why when
There's billions of debt, so how many millions of dollars you want to invest in debt that's not likely collectible? So you're in good standing. You really are. Listen to what he has to say. This stuff is very interesting. Yes.
That's why when the franchise tax board passed the debt to the collector, and I started contracting with the debt collector, they very quickly sent it back. Do you think the franchise tax board gave them their money back? No, because they didn't pay anything for it. It's a commission deal. We collect, we get to keep a portion of what we collect. So how much did they pay for it? Nothing. So that's all you owe by law. Number 12. Did debt collector purchase this alleged account from a previous debt collector? Yes or no? Date of purchase of this alleged account from previous debt collector and purchase amount. Number 14. Regarding this alleged account, debt collector is currently the A, we give them multiple choice even, is either A, owner, B, assignee, or C, other. Please explain. What are the terms of the transfer of rights regarding this alleged account? That's number 15. Number 16, if applicable, transfer of rights regarding this alleged account was executed by the following method. Give a multiple choice. A, assignment. B, negotiation. C, novation. What's a novation? Do you have a definition stored up? What's a novation? New.
Three-crime contract.
It's just a replacement of a debt with another debt.
Right.
Real simple.
Number 17, if the transfer of rights regarding this alleged account was by assignment, was there an equal exchange of consideration? Yes or no? 18, what was the nature and cause of the equal exchange of consideration cited in number 17 above? If your answer was yes, explain. If the transfer of rights regarding this alleged account was by negotiation, was the account taken for value? Yes or no? 20. What is the nature and cause of any value cited in number 19? If your answer was yes. 21. If the transfer of rights regarding this alleged account was by novation, was consent given by alleged debtor? Yes or no? What is the nature and cause of any consent cited in number 21 if your answer was yes? 23. Has debt collector provided alleged debtor with the requisite verification of the alleged debt as required by the Fair Debt Collection Practices Act? Yes or no? Date of said verification cited in number 23 above, which provided alleged debtor. Was said verification cited in number 23 above in the form of a sworn or affirmed oath, affidavit, or deposition? How many of you have ever gotten an oath, apposition, or deposition from a debt collector?
Never.
I don't imagine you ever will. Number 26. Verification cited in number 23 above. If your answer is yes, was provided alleged debtor in the form of oath. They just got to circle one. Oath, affidavit, or deposition. Number 27. Does the debt collector have any knowledge of any claims, defenses regarding this alleged account? Yes or no? 28. What is the nature and cause of any claims, defenses regarding this alleged account? Number 29. Was the alleged debtor sold any products/services by the debt collector? Number 30. What is the nature and cause of any product services cited in number 29 above if your answer was yes? Number 31. Does there exist a verifiable, bona fide, original commercial instrument between debt collector and alleged debtor containing alleged debtor's verified, bona fide signature? Yes or no? 32. What is the nature of any verifiable commercial instrument cited in 31 above, if your answer was yes? Number 33. Does there exist verifiable conclusive evidence of an exchange of a benefit or detriment between debt collector and alleged debtor? Yes or no? 34. What is the nature and cause of this verifiable conclusive evidence of an exchange of a benefit or detriment as cited in number 33 above, if your answer is yes? Number 35. Does any absolute evidence exist of verifiable external acts giving the objective semblance of agreement between debt collector and alleged debtor? Yes or no? What is the nature and cause of any external acts giving the objective semblance of agreement as cited above in number 35, if your answer was yes? Have any charge-offs been made by any creditor or debt collector regarding this alleged account? Yes or no? Have any insurance claims been made by any creditor or debt collector regarding this alleged account? 39. These are all yes-nos. Have any tax write-offs been made by any creditor or debt collector? Yes or no? Have any tax deductions been made by any creditor or debt collector regarding this alleged account? Yes or no? 41. Have any judgments been obtained by any creditor or debt collector regarding this alleged account? Yes or no? 42. Does the debt collector and or creditor purport to have and to hold a verifiable contract where an equal exchange of consideration exists between the debtor with the debt collector and or the creditor? Yes or no? 43. What is the nature and cause of this verifiable contract cited in number 42 above if you answered yes? Number 44. Does the debt collector and or creditor purport to have and to hold a verifiable contract which purports to have a bona fide signature of debtor? Yes or no? Number 45. Does the debt collector and or creditor purport to have and to hold a verified contract which purports to have bona fide signature of alleged debtor which the debt collector and or creditor has first-hand personal knowledge of and will verify under oath, affirmation, deposition under penalty of perjury? Yes or no? 46. If debtor and or creditor purport to have and to hold, I feel like I'm doing a marriage thing. If debtor and or creditor purport to have and to hold a verifiable contract which purports to have a bona fide signature of debtor, please produce a true, correct, and complete copy of said contract and verify under oath, affirmation, deposition under penalty of perjury that debt collector and or creditor has first-hand personal knowledge that the debtor's signature appears thereon, or state the nature and cause why the debt collector and or creditor will not produce said contract, which purports to have a bona fide signature and cannot verify under oath, affirmation, or deposition to having first-hand personal knowledge as cited in number 45 above, if answered yes. Number 47, does the debt collector and or creditor have any type or kind of verifiable claim which complies with all the provisions set forth in the Fair Credit Reporting Act codified at 15 U.S.C. subsection 1681 et sequata? Yes or no? 48. What is the nature and cause which debt collector and or creditor rely upon for such claim, and what procedures were implemented in accord with the Fair Credit Reporting Act to investigate such claim, cited in number 47 above, if answered yes? Number 49. Does the debt collector and or creditor have verifiable facts which they rely upon in order to provide credit reporting agency with information on alleged debtor which complies with the provisions set forth in 15 U.S.C. subsection 1681 S2 and which is verifiable in accordance with 15 U.S.C. 1692G? Yes or no? Number 50. What is the nature and cause which debt collector and or creditor rely upon for such verifiable facts, and what procedures were implemented in accord with above said provisions cited in 49 above, if answered yes? Number 51. Did the debt collector and or creditor advise the alleged debtor of the numerous rights which he maintains as accorded in the Fair Debt Collection Practices Act codified at 15 U.S.C. subsection 1692 et sequata? Yes or no? 52. What is the nature and cause which the debt collector and or creditor relies upon which is verifiable and clearly and accurately identifies how and when the debt collector and or creditor informed debtor of such right accorded and cited in number 51 above, if answered yes? 53. Does the debt collector and or creditor have any verifiable, articulable facts which they rely upon to furnish the credit reporting agency with unverified, inaccurate, erroneous information in violation of the provisions set forth in the Fair Credit Reporting Act, 15 U.S.C. Subsection 1681D, 1681I, 1681N, 1681O, 1681Q, 1681S, and 1681S2, and the unfair or deceptive act or practices in commerce in violation of 45A of the Federal Trade Commission Act, codified in 15 U.S.C.G. 45AB, and the Fair Debt Collection Practices Act, codified in 15 U.S.C. subsection 1691 B, C, D, E, F, G, I, J, K. Number 54, it's the last question. What is the nature and cause of these verifiable, articulable facts which debt collector and or creditor relies upon for providing unverified, inaccurate, erroneous information in violation of the provisions set forth and cited in number 53 above? If answered yes. If answered no, provide proof positive of verifiable facts relied upon under oath, affirmation, deposition, and under penalty of perjury that verifiable proof of claims exist. Debt collectors and or creditors' failure/refusal, both intentional and otherwise, in completely, unambiguously answering points 1 through 54 above and returning this debt disclosure statement, as well as providing respondent with requisite verification validating he herein above referenced, that should be the herein above reference alleged debt, constitutes the debt collectors and alleged creditors' tacit acquiescence that debt collector and or creditor have no verifiable, lawful, bona fide claims against respondent in above referred alleged account or any and all other alleged accounts not specifically enumerated herein. Debt collector and or creditor, by its their failure refusal to respond and or its their failure to provide each and every verified requisite proof as requested herein within 30-day time period allowed, will constitute the debt collectors and or creditors waiver of any and all alleged claims against respondent and indemnifies and holds harmless respondent against any and all costs and fees heretofore and hereafter incurred, including but not limited to any and all related collection attempts involving the herein above referenced alleged account and any and all related accounts. Declaration. The undersigned hereby declares under penalty of perjury of the laws of the state of California and the United States of America that the statements made in this debt collector disclosure statement are true, correct, and complete and not misleading in accordance with the undersigned's firsthand personal knowledge and belief. And there's a little notice down here at the bottom. Debt collector must timely complete and return this debt collection disclosure statement. Debt collector's alleged claim will not be considered if any portion of this debt collector disclosure statement is not completed and timely returned with all required documents, which specifically includes the requisite verification made in accordance with the law and codified in the Fair Credit Reporting Act at 15 U.S.C. subsection 1681 et sequata and the Fair Debt Collection Practices Act at 15 U.S.C. subsection 1692 et sequata, and which states in part a debt collector may not use any false, deceptive, or misleading representation or means in connection with the collection of any debt and the threat to take any action that cannot be legally taken, all of which are violations of law. If the debtor or if the debt collector and or alleged creditor do not respond as required by law, debt collectors and or creditors' alleged claim will not be considered, and debt collector and or alleged creditor may be liable for any and all damages for any continued collection efforts as well as any damnification sustained by respondent. Please allow 30 days for processing, excluding the day of receipt after respondents and CRA's receipt of debt collectors and or alleged creditors' response. So you think they're anxious to answer that? What happened when you sent it out?
I've had the occasion to use this form for a long, long time. And this form is as effective as your first impression is of it. I've yet to see it ever be responded to other than tacitly, thereby admitting there is no valid debt and no negatives have appeared on the people's credit reports, etc. You have a question?
Yeah, I do.
Microphone.
Get to that, hang on.
Hello? Quickly, regarding novation, you say it's a transfer of one debt for another. Is it necessarily between two distinct parties?
Debt's a debt. Are you going to agree to a debt?
I'm just asking, is novation necessarily between two distinct parties?
Could be or couldn't be. If it's
So
just
maybe
replacement
not.
of one debt for another.
Okay.
Does it mean two parties, three parties,
One party?
one party?
Okay, that's what I wanted to
Sure.
know.
Yes.
Gordon, quick question. As a certified paralegal, with reference to Civil Lit 3, this appears to be a set of interrogatories. Is that correct?
It would seem so, is it not?
There is a limit on specific interrogatories. I think the number is 35, and then there's an unlimited number of non-specific. And I would ask anybody that is an attorney to check this to see that it isn't violating those limits on specific or non-specific interrogatories. This whole thing is a series of interrogatories.
Can
Is
I
it
not
a
make any
private
contract?
Pardon?
Isn't it a private contract?
Yes.
Can I not contract any way I wish? Can I make any counteroffer I wish?
Thank you.
Let's pass the mics around so we can answer any questions.
Sorry about that. Okay, so I'm just trying to stretch things a little bit here. Each one of these collection agencies sends you a letter, which is in essence a contract, and it gives you an account number, and it assigns a value to the debt that they claim they have, or it assigns a value on there, right? Is there any reason why you couldn't OID that amount from that account number for each debt collection agency at the end of the year?
Well, are they not? It's not a contract they've sent you. They sent you an offer, have they not?
Yeah.
Isn't it all offer and acceptance?
Mm-hmm.
Got 4 doors with every offer. Do you want to pay something that's not valid?
No.
Something that can't be proved?
No.
Of course, nobody can prove anything, so it gets really interesting, doesn't it? We're headed to a cashless society. Is that good or bad? Looks to me like it's pretty good.
Hold on, before the next question, let's go ahead and switch the video out. All right, we'll take Fred's question. No, and then we'll
Fred.
transfer the
It's
mic.
not so much a question, Brandon, but getting back to your original private
He loves to make statements.
international remedy agreement, and you defined it as between two diverse parties.
Did I say diverse?
Yeah, you did.
Maybe distinct.
Distinct parties. With specific reference to Title 28, Section 297, the circuit courts agree
Fred,
to...
why do you keep trying to bring code into my contract?
Just hear me out a second.
Okay.
Agree to send their judges into the freely associated state courts for certain purposes. And then in paragraph B it says they reference these freely associated state courts as countries. So they're distinct countries by that 28 U.S.C. 297. You might want to look into that to add it as a point of law. It's very important.
Well, what's a court? What's a